It's, so yes, there's some cooperative federalism going on there, but it's a tricky act if you are a state government or a local government and you're trying to regulate waste sites. And we're going to talk about preemption in just a moment. Okay, so another mechanism involves corrective actions that require the cleanup of contamination, and then, so we're talking about that in just a moment. I'll just list it here. And then finally, one of the things that's sort of a problem with RCRA, one of the limitations is that it doesn't really facilitate or incentivize the production of less waste. There's no real strong mechanism there that really means we're going to produce less waste, and so that's a challenge. Okay. So there are some EJ issues with RCRA, and several EJ issues that are, first of all, highly relevant to problem number 3, and then also raise some interesting issues. Okay, so first of all, there are questions about siting these facilities. Any of the facilities are subject to RCRA regulation. So obviously, even though landfills get less regulation, they get some regulation under Subtitle D of RCRA, and they are, again, disproportionately cited in low-income communities of color. I'll start referring to them as EJ communities. Okay? TSD facilities for hazardous waste. I already mentioned they are disproportionately located in EJ communities. One of the other big issues that has come up in the environmental justice movement has to do specifically with hazardous waste incinerators, where there's an intersection between RCRA and the Clean Air Act. Okay, so while there are entirely separate regimes between RCRA and the Clean Water Act, and so forth, they're actually, when it comes to hazardous waste incinerators, you have both RCRA and the Clean Air Act that end up being applicable. But even things like the hazmat traffic routes. Okay, so a lot of EJ communities are very concerned about what is being transported through their neighborhoods. So think about, if you've got instead of the hazardous materials going right through the middle of downtown, they're going all the way around the Watterson, right? They're going right through West Louisville on their way to I-64, right? Or from I-64, right? Okay, so that's a concern in those neighborhoods. Also, very often, the neighborhoods are located near rail transportation, right? Okay, how many train accidents have you seen on the news in the past 5-10 years around here, if you happen to be around here, and if you're not, you've probably seen them in your own home communities, right? But where there's like something really bad that is now contaminating the environment, and they have all these emergency response teams and hazmat crews and so forth, right? So right down in Bullitt County a few years ago, it was like really bad looking stuff, and they had everything blocked off, you couldn't drive anywhere and so forth, right? Because you got hazardous materials being transported on the trains. And those oftentimes in urban areas, they're more likely to go through or near the lower income communities. So when it comes to the siting, the decision about whether that is going to be allowed in a particular community, one of the challenges is, yes, there are federal standards, and yes, they are aimed to prevent contamination and to protect the public health and safety, and there are also public participation opportunities and so forth. The participation is not really what we might call engagement or inclusion, right? It's a very sort of formal process. People do get to have their say, but it's not really a cooperation between the regulators, the facility proponents, and the neighborhood where it's going to be. In addition, there are a whole variety of state and local regulations over the years that have been deemed to be preempted by the federal standards. Okay, and so those of you who really are very excited to know that there is some application of the Dormant Commerce Clause, you're like, oh God, not that, right? Yeah, not the Dormant Commerce Clause, but yes, it rears its ugly head right here in environmental law, and so it's an issue, right? I mean, basically, to some degree, with some exceptions in the statute, in the state plans and so forth, to some degree, courts are more likely to say RCRA occupies the field of citing these waste facilities. And so state and local regulations that might aim to protect neighborhoods or make it difficult or impossible to cite these facilities in certain places have been deemed by the court to have been preempted. So that's a problem. And then the question is, are the decision makers about these permits considering environmental justice at all? Okay? What we're going to discover next week is theoretically they're supposed to under a federal executive order and a presidential order, but the reality is generally they're not. Right? They're generally not looking at things like, is a particular neighborhood overburdened already? Is there is there disproportionate impact on a particular neighborhood? Does this neighborhood have any special vulnerabilities in terms of human health or exposure or risk? And I'm not saying that those aren't ever considered, but generally there are not very many good mechanisms for requiring or forcing the EPA officials that are doing this to consider. Because generally, what they're looking at is, here's a checklist of all the things that have to be done in order to get your RCRA permit, and they're just kind of going through that, looking at whether it meets that. The other thing that's going on, of course, is there's this assumption that these things have to be cited somewhere, right? We all need landfills. We all need, we all use things in our world that that generate hazardous waste in some way or another. And the question is where we're going to put them. And as you can imagine, that higher income communities that are more white, have more political power, more political clout to keep them out of their communities, right? I mean, I'm not without the East End. There's not that many TSD facilities out there. There's not, right? Okay, so I mean that's just the reality of how this has played out in a very unequal and environmentally unjust way. So that's a real limitation to RCRA. That's what I'm saying. It's a limitation to RCRA. Another issue has to do with enforcement issues, under enforcement, disparities in enforcement. So the EPA has authority to enforce its permits under sections 3005 to 3009 of the statute. Okay? And so this is a useful set of enforcement tools about the permits, but it often is very narrowly tailored to whether a permit condition has been violated or not, right? Okay, so it all depends on what's in the permit and so forth. What's interesting about RCRA is there's an entirely different set of sections, and what we care about at this moment is section 7003, which is the corrective orders section where the EPA has the authority to seek injunctions against anybody that is going to potentially cause contamination that would impose an imminent and substantial endangerment to the health or the to human health or the environment. Okay? So that's the imminent and substantial endangerment section or clause, and so this gives the EPA actually pretty broad authority that even if something hasn't been regulated, even if there's no permit condition available, they can take very proactive action and say, hey, you know, for example, your drums are deteriorating, and you need to take immediate action to contain the waste and replace the drums. And if you don't do it, we're going to go seek a court injunction forcing you to do it right now. Okay? And so that's a very powerful tool. And so one of the things about the that is different between 3005 and 7003 is with 7003 you can not only prevent danger prospectively, but you can also impose retroactive liability for correcting the harm. The EPA can. Okay? So that's one of the advantages. Relevant to environmental justice groups like the one that we're representing is Section 7002. Section 7002, citizen supervision. So this is also a provision that allows any citizen group, so that includes any environmental group, includes any environmental justice group, to bring a lawsuit seeking an injunction against any potential contributor of contamination to the environment, contamination, hazardous waste environment, to prevent imminent and substantial endangerment to human health and the environment. Okay? So it's the same standard, the imminent and substantial endangerment standard, and it basically says, you know, citizen groups, environmental groups can bring this, and mere risk of harm is enough. There are some significant limitations. They're not on the slide, but we'll add them to your notes. Okay, so one big limitation, I just ran under one, I'm sorry. One big limitation is that the environmental group cannot bring the suit if there's an ongoing federal agency action. If there's an ongoing federal agency action, usually we're talking about the EPA. Generally, actually, if a state government is taking action, they also are precluded from bringing the suit. So federal or state government action to prevent the contamination, then the environmental group cannot bring the suit, okay? Because the theory behind this is we need to give the regulatory agencies the time to address this. They're our first preference, and only if they don't act, only then will the environmental group bring the suit. Secondly, is that before the environmental group brings the suit, there is a 90-day notice rule, 90-day notice rule. They have to give the prospective defendant, whoever the cause or likely generator of this hazardous contamination, and the relevant federal agencies and federal and state agencies notice that they intend to bring the suit. Because again, the idea here is instead of going to court, we would rather that the prospective polluter take action to prevent their pollution or stop their pollution, or that the federal or state agency will take action against them, rather than having this sort of play out in court. Okay, so those are a couple of significant limitations. And another limitation is that while the environmental group can get an injunction that requires the polluter to spend money to correct the harm, if the environmental group or somebody else, local government or whatever, has spent the money themselves to correct the harm, they cannot get restitution. Okay, so it's only injunctive relief, not restitutionary relief. Okay, right? So that is also relevant. But another key point that's not on this, but it fits with what we said before about the Clean Water Act, the successful environmental group can get attorney's fees. Okay, so this again is favored by environmental groups because they can get attorney's fees if they're successful. But as you might imagine, if the polluter doesn't want to pay attorney's fees, and they don't want this sort of angry environmental group going after them, what are they going to do? They're either going to come into compliance themselves, or what are they going to do? They're going to ask the federal government to take action against them within the 90 days, right? Because A, they think that the federal government is easier to negotiate with than the upset local group, right? And B, they won't have to pay attorney's fees. Right? Does everybody see sort of the litigation strategies on that? So what does that mean? It means that there are some potential tools that an environmental justice group like the one you're representing has, but there are also some significant limitations to the use of those tools, right? And if the EPA is under enforcing, the group has some opportunities to try to enforce that. They also have some limits there. All right, so now let's turn to CERCLA, the Comprehensive Environmental Response, Compensation, and Liability Act, which is a Superfund law. And the basic concept is you have strict joint and several liability for the cost of cleaning up, including remediating. Remediating is not the only type of cleaning up, but it's the most common. Right? Hazardous substance contamination for any contributor to the contamination and any owner or operator of the site of contamination, subject to certain exceptions. Okay, so the whole idea here is to generate funding for contaminated site cleanups. So when does CERCLA apply? So first of all, it applies to any release or substantial threat of release into the environment. And just look at page 255 for the definition. It's like a whole laundry list. It is the author said it looked like some intern on Capitol Hill just got out of the thesaurus and went through everything that could possibly happen. That's a little snarky, but it's a very broad list. Okay. And it applies to any hazardous substance, which is also extremely broad. That includes any substance that is designated as hazardous under any of a whole number of federal pollution statutes. Okay? So not just the RCRA list, and not just the RCRA list. In addition, the EPA can list things that count as hazardous substance, and furthermore, the EPA can just decide on a case-by-case basis, make a determination that a particular substance poses risk of imminent and substantial endangerment to public health and the environment. Okay, so much broader, right? RCRA has a much narrower, it has a pretty broad definition, but this is an even broader definition of what counts as a hazardous substance. By the way, it does not have to be a waste. Notice we're talking about hazardous substance, not hazardous waste. They don't have to be waste. It's way beyond RCRA. However, petroleum and natural gas is expressly exempt. I think I couldn't decide whether I was going to say exempted or exempted, so instead it's French exempt. So anyway, all right. And then third, it applies to any facility. Okay, that is also extremely broad. It's basically any place or structure, site, building, pipe, conduit, whatever. Basically, if it's got a geographic existence, it's a facility. There is one basic command and control regulatory requirement in CERCLA, which is any person has a duty to notify the EPA of any known release of a reportable quantity of hazardous substance. Okay? So that is a regulatory requirement that applies to any person. You know of a release of a reportable quantity of hazardous waste, you have to report that to the EPA. We are going to start talking about sites because we're talking about what we're cleaning up. So sites are usually a particular facility, maybe it's a set of facilities, but we're talking about a particular place where we have contamination of hazardous substance already. There are likely hundreds of thousands, perhaps millions, of sites nationally that are contaminated in some way with some hazardous substance to which CERCLA would apply. And those sites are a much broader universe than the sites that are on the National Priority List. NPL, okay, is the National Priority List. This is the Superfund list. Okay? These are the sites that the EPA has determined are the most contaminated, the most important to address, and cause the biggest risk of endangerment to public health and environment. In 2018, according to the book, there were more than 1,340 of those sites nationally. Okay? So when somebody says that something's a Superfund site or a National Priority List site, this is a subset of all contaminated sites, and they're ones that have been specifically picked by the EPA for more attention or are more significant in some way. So what happens if you have a contaminated site? So the site is contaminated with hazardous substance. So again, site or facility contaminated with hazardous substance. Well, one possible response is what's called removal, and that is a more immediate containment and removal of things that are probably doing some really bad stuff to the environment or the human health right away. So again, this is things like you have a train wreck and you've got bad stuff spilling out into the onto the tracks and into the environment and into the air in Bullitt County, and you got people in their hazmat suits coming in to address that. That's going to be removal. Remediation is really what we generally mean by cleanup, by a longer-term plan to, and it might involve removing the stuff, okay, taking it out of the soil and disposing of it somewhere else. It might involve somehow treating maybe groundwater in a way that's going to break down the bad stuff and make it not bad. Okay, right? So there's various things that can be done there. Okay, it might involve pumping out some of the groundwater and replacing it with clean water or that kind of thing. It might. One of the common remediation techniques now is you leave it in place and you cover it over in a way that is presumably going to prevent human contact. Okay, so for those of you who went down to the waterfront park, right? Okay, so that's exactly what happened with Waterfront Park, right? They told us about that. They said it was going to be far worse to take it away somewhere, and then you're going to be liable under CERCLA for if there's contamination at whatever disposal site. So instead, they brought a bunch of dirt in, covered it over, and then planted over, paved over, right? Everybody remember that? Yeah. Okay. So and so that works, but we also have situations where that's supposedly what happens, and there is an elementary school built on that site, and lo and behold, it's not staying contained, and the kiddos are being exposed to some sort of contamination in what has turned out to basically be a failed remediation. Okay, so that happens. I mean, you see that in the news, and it's not good. So the question is, what is the remediation, and is it adequate, and so forth. Any CERCLA response has to meet the National Contingency Plan requirements, NCP requirements. This is just terminology that gets used. So again, if you're talking plans, you have a National Contingency Plan. And so this includes remedial investigations and feasibility studies, we call RIFS, public consultation, so you're supposed to have participatory processes that allow the public to engage with it, to comment on the proposed cleanup, the proposed plan. This is something that EJ groups very much want to do. Again, they find sometimes real barriers to effective participation. They find sometimes it's very technical. Sometimes the participatory processes aren't very inclusive. There are times that don't work for them or that they don't have access to, and so forth, but that is part of what's supposed to happen, is that the public is engaged. There is a cleanup plan that is subject to, and it's usually both EPA approval and state approval. So this is oftentimes where the state government definitely is involved in reviewing and making recommendations about this. The cleanup standards are what are called ARARs, applicable, relevant, and appropriate requirements. This is where we get the cleanup standards, ARARs. Okay, as the book pointed out, ARARs come from a variety of things that come from, in part, EPA regulations, but they also come in part from a whole variety of environmental statutes. Okay, so if groundwater is relevant, you might find that certain kinds of groundwater regulations are used to determine what kind of cleanup has to happen. There is a lot of bargaining, negotiating, jockeying back and forth, disagreement about cleanup standards. What are they going to be the ARARs? Is this really going to achieve? Is this remediation plan really going to achieve the ARARs? Right. So just think again about the covering over all those contaminants and building an elementary school on top of it. Right. That might be totally different than if we're building a parking garage, right? In terms of human exposure, et cetera, right? And so that ends up being the kinds of questions that get raised there. And as you see in the book, there's a whole discussion of how clean is clean. And this is something that EJ communities care a lot about. EJ communities are especially concerned that a lot of times for them, for the CERCLA facilities in their neighborhoods, that the ARARs are very lax. That the cleanup standards are very lax if you compare them to the cleanup standards elsewhere. Okay, right? So, if, for example, and I really don't know what they are, but you can imagine that the cleanup standards for building the Cardinal Stadium, our football stadium, is built on a brown field, right? Everybody, do you guys know that? You know that? No, it was a CERCLA site where the football stadium is for the U of L. Okay, it wouldn't be used for anything else, right? Because it was sort of sitting there contaminated. But you can imagine that maybe the university pays a whole lot more attention to that than in a whole row of industrial facilities in West Louisville. Maybe regulators are being more lax, more permissive with cleanup standards there, and so that's a concern. The thing that everybody should take away from this though is if CERCLA liability applies, we're talking about very substantial cost of cleanup. often in the millions of dollars, sometimes tens of millions, sometimes hundreds of millions of dollars for these cleanups. They are very costly, and the process itself is also very costly. So how does this work? Well, first of all, there are EPA cleanup and cost recovery actions against. So okay, one possibility is EPA cleans out itself and then brings a what's called a cost recovery action against PRPs. PRPs are potentially responsible parties. You'll see that on the next slide. Another possibility is that the EPA orders the PRPs to engage in cleanup at their own cost. Okay? This is challenging for PRPs because no pre-enforcement legal challenges are allowed. You cannot. So you can bring a suit, but if you are not cleaning up while your lawsuit is pending and you lose your lawsuit, you are paying treble damages plus fines for every day that you didn't do the cleanup because when the EPA had ordered you to do so. So I mean, you can imagine the regulated community doesn't like this at all. But if you do win your lawsuit, so if you do the cleanup at your cost and you bring a lawsuit against the EPA for an arbitrary and capricious cleanup order, right? And you're going to cite which statute? Obviously, circle limit, you're also going to cite which other statute? The APA, right? The APA, right? Okay, so Administrative Procedure Act would be the judicial standard of review. Was their cleanup order arbitrary and capricious? And if the court says yes, you can recover your costs from the EPA. The other thing is PRPs can voluntarily clean up themselves, right? And choose to undertake this. Where some PRPs clean up or pay for cleanup themselves and then want other PRPs to pay their share, they bring what are called contribution actions. So cost recovery actions and contribution actions are they're both in the statute, but they're two different kinds of things. And there's a whole Supreme Court case that differentiated all this, which seemed actually obvious if you paid attention to what the statute says, but nonetheless people got confused about this a lot. So contributions are where PRPs are suing other PRPs. The federal and state governments and sometimes local communities can seek natural resource damages. Okay, so that's a specific provision in the statute that allows recovery of, allows the plaintiffs, the government or the community to get money from the PRPs for the damages they cause to natural resources. And I'm going to try to get a little bit further on this before we have to end. I just want to tell you, just from practice, one of the practical issues is if your client is a PRP in a cleanup action, right? You have to be very proactive about protecting your client's interest. Otherwise, you're going to be stuck with a really big bill for things that are not really your client's fault, or not really they're disproportionate to your client's contribution. In addition, there are some opportunities. I'm going to flag that, and I'm going to show you in just a second what one of the opportunities is. So, who are potentially responsible parties? They are current owners and operators of a facility, regardless of fault. They are prior owners and operators of a facility at any time that the hazardous substance was disposed there and/or in the process of contaminating the site. Again, without fault. Any generators that arrange for the disposal or treatment of the hazardous substance that ended up there. And transporters, but only if they played a substantial role in the selection of the facility. So what you get is strict, joint, and several retroactive liability for response costs. What does that mean? Strict means without regard to fault. Joint and several means each and every PRP is liable for the entire amount. So obviously the bankrupt PRPs, the PRPs that are no longer in existence, Bad Chemical Corporation that went bankrupt in 1962, you're not going to get anything out of them. They're gone, right? And so forth. And retroactive means you're paying for things that happened in the past, not just what you're doing going forward. It does not depend on negligence, intent, or harm. There are defenses, acts of God, war, or third parties. Okay, don't get carried away with this. These almost never apply because even if, say, hey, a hurricane was responsible for this, they're going to say yes, but the hurricane wouldn't have led to this contamination if you weren't storing your hazardous substances in these drums outside, where in a place where hurricanes come and happen. So don't carry away with that. There's an issue about divisibility. If you can really truly divide up, this party caused this amount of pollution over here, that party caused that amount over here. Small contributors, de minimis and de micro settlements are allowed under the statute. These are some things that have been added. So if you're a small contributor, you can get by with. You still have to pay, but you can get by with these very small contributions to the cleanup. And municipal solid waste. If you're generating a small amount of contribution, you can get an exception there. Lenders, whose only interest in the property is holding a security interest, but lenders have gotten themselves in trouble because once they get involved in directing any decisions regarding the site and how it's operated, they lose that exemption. Okay? So that's something, again, that the environmental lawyers have to advise lenders about. And then finally is the innocent landowner or purchaser defense. Okay? We will pick up with the innocent landowner or purchaser defense, finish this, and then there's only one more slide that talks about the EJ issues surrounding brownfields, which we will do all that on Monday, and then keep moving forward with the EJ reading.